Today I will give you all the information you'll need to know about the small claim case. Here we go. Part 1.2 If there is no ground for outright dismissal, issue summons and notice hearing. 3.1 The summons and notice of hearing, which are required to be issued within the same day of receipt of the statement of claim under Section 10, must be issued within 24 or from such receipt, the phrase same day to be construed as within 1 day. 3.2 Do not wait for summons to be served before setting the case for hearing. 3.3 The hearing should be set within 30 days from receipt of the case. In case the defendant resides outside the judicial region, the hearing may be set not later than 60 days from date of receipt of the case. 3.4 Failure of the plaintiff to cause service of summons within 2 months from receipt of sheriff's return shall cause the dismissal of the claim for failure to prosecute, Rule 17, Section 3, Rules of Court. This is not a ground to archive the case. 3.5 Any party who appears at any time after the court's receipt of the case should be notified immediately of the date set for hearing. 3.6 There should be, at least, one hearing day every week devoted to small claims, with a minimum of 5 cases scheduled per hearing day. Cases with the same party plaintiff may all be set on the same date for facility in the preparation of notices and judgments. The court should post a notice of its small claims hearing day conspicuously at the branch and at the office of the clerk court. 3.7 Judges must approve an estimate of expenses submitted by their sheriff/process server within 24 hours from filing before any release from the STF is allowed. On the date of the hearing. 4.1 Make an opening statement, Section 20, see also Form 6A SCC, explaining to the parties the object of the rule and the procedure for hearing the case. Ensure that the parties understand the proceedings and actively participate therein. 4.2 Conduct settlement discussions in strict confidentiality. Try to explain to the parties why an amicable settlement will be mutually beneficial. 4.3 The drafting of a comprise agreement should be part of the hearing conducted by the judge. This will ensure that an agreement will be forged within the day of the hearing to pave the way for its approval by way of the required judgment, to be issued also within the same day. It will also reduce the incidence of inclusion of terms which are contrary to law, morals, good customs, public policy, and public order. 4.4 Have a template of a compromise agreement ready. The parties may be referred to the branch clerk of court or the clerk in charge for assistance in filing up the template, whether before or after the case is called in open court. 4.5 In all instances, review the terms of the compromise agreement submitted by the parties. Do not approve terms which are unconscionable and excessive, especially those relating to interest rates and surcharges. In the latter instance, in your judgment approve the agreement in part, substitute, and impose a provision which is reasonable, to replace those you have disapproved for being excessive and unconscionable. 4.6 In case a non-answering defendant appears at the hearing, recognize his appearance only if he is willing to enter into discussions of settlement, but guard against coercing the defendant to enter into one. 4.7 If a non-answering defendant appears at the hearing and agrees to discuss a settlement but pleads partial payments, which the plaintiff admits, but no settlement is ultimately reached, render judgment based on the statement of claim. If the plaintiff waives in writing, even in the minutes of hearing only, the confidentiality of the settlement discussion, you may consider the admission of partial payments in rendering your decision. 4.8 If at any time before or at the hearing, a compromise agreement is submitted signed by both parties but only one or neither party appears to confirm it, issue an order to the non-appearing party to confirm it within 3 days, otherwise it shall be deemed confirmed. Then issue a judgment based on the agreement. 4.9. If no settlement is reached and the parties do not wish to have another judge hear the case, proceed to the hearing proper in an informal manner and terminate and decide it within the same day. Decision and execution. 5.1. Whether based on an amicable settlement or on the merits, judgment must be issued on the same date of the hearing, except when there is a motion by any party under Section 22 to have another judge hear the case. 5.2. Upon issuance of the decision, have copies served on all parties present to avoid mailing them. 5.3. A decision under the rule is immediately final and executor. It must be recorded in the Book of Judgments on the same date it is rendered. 5.4. There is no appeal and, hence, no period to appeal to wait for. 5.5. On the same day the decision is rendered, the winning party may move for its execution. B. Guidelines for executive judges, clerks of courts, COCs, in multi-sala stations and in single-sala stations and branch clerks of court, BCCs, the clerks of court and the branch clerks of court, even non-lawyers, may administer the oath to litigants for the forms to be used under the rule. No fee shall be collected for this purpose. The clerks of court should not accept mere photocopies of documentary annexes submitted by the parties but should monitor strict compliance with sections 5 and 11 of the rule. The clerks of court should have a separate docket for small claims cases with independent numbering. Should a case, originally docketed as a small claim, be ordered redocketed, i.e., it is governed by the rule on summary procedure or regular procedure, this should be recorded in the appropriate docket and a new number given to the case. However, the case should not be re-raffled but should immediately be sent back to the original court after redocketing. The clerks of court should only ask for two The clerks of court should only ask for 2 copies of the pleadings and all their annexes, one for the court and one for the defendant. If there is more than one defendant, that is the only time the OCC may require additional copies, one for each additional defendant. The clerks of court can only certify photocopies of documents if the originals are presented to them by the party who does not want to leave the same with the court. In that instance, the COC can certify that the document is a faithful reproduction of the original exhibited by the party. No fee shall be charged for this certification. If, despite advice to the contrary, a litigant insists on the filing of a vase as a small claim, the COC should reiterate the previous advice given in a respectful manner and then docket the case. Requests for advances for transportation expenses from the Sheriff's Trust Fund should be acted upon within 24 hours from receipt of the approved statement of estimated expenses. The clerks of court should ensure that the full names and addresses of the parties are indicated in the statement of claim, as well as alternative contact information, such as telephone numbers, when possible. The monthly docket inventory report should reflect the date when a case is decided or disposed of vis-a-vis the date of filing so that the timeliness of court action may be assessed. The date when summons was issued and the date of hearing should also be indicated. Finally, the execution and satisfaction of judgments rendered under the rule should also be part of the monthly report to determine the rule's efficacy. 1. The rule on inhibition in regular cases shall apply to small claims courts. An additional fee of P500.00 should be assessed any litigant for the 10th small claim filed, and for every 5th additional case thereafter. The fee is justified by the service availed of which requires extra time and effort on the part of the courts. The volume of cases filed evidences the capacity of the litigant to pay the fees. On the same day of filing/raffling of the statement of claim, the clerk of court shall transmit the record of the case to the branch assigned. The branch clerk of court, BCOC, shall forthwith inform the plaintiff of the date of hearing of the case. Upon receipt of a newly filed/raffled small claim, in case the presiding judge is on leave, the BCOC shall immediately refer the case to the pairing judge for appropriate action in accordance with existing rules. Sheriffs and process servers shall serve the summons and notice of hearing within 5 days from issuance, unless the distance justifies a longer period, but in no case shall service be effected beyond 30 days from date of issuance. Within 5 days from such service, the officer's return shall be filed with the court with a copy furnished to the plaintiff at the given address/es of record. And, d. Nationwide implementation/rollout of the rule on procedure for small claims cases, as amended, to all first-level courts, except the Charrier Circuit Court, effective 30 days from date hereof. Let this resolution be published in a newspaper of general circulation. ADV 102, very truly yours, continuation next video, part 2.1. If you find IT helpful or educational, kindly hit like, share, and ring the bell, comments down below for more videos and updates, and don't forget to subscribe my channel. Thank you for watching. Have a blessed day ahead.